I was at a board meeting at Jews for Jesus. I was on the board at the time, and the executive director said, we've got a case. The Supreme Court had just granted review. It was about literature distribution at airports, evangelism at airports. The Ninth Circuit had allowed the evangelism to take place, but the Supreme Court had accepted the case for review, and the thought was that they were going to reverse and not allow evangelism to take place.
So we should decide this case as though the question is, could LAX, like the Capitol, promulgate a nicely, narrowly crafted rule that says no religious proselytizing on these grounds, right? And that's the issue. Could LAX do that? If it's a public forum, it couldn't. If it's not a public forum, presumably it could.
Your Honor, the Court has before it facts which have been stipulated by the parties showing exactly what's taken place in LAX, the activities that have taken place. In our briefs and in the trial court briefs, we have argued these other points. We would take the position that this Court could reach these other issues. Viewpoint discrimination, regardless
precisely, you're asking us to Mr. Sekulow, would you explain to me, because I really don't understand this from your argument, what is it that makes a public forum special as opposed to any public building? Because as I understand your argument, I think what it boils down to saying is that any public building must be allowed to be used for free speech activities to the extent that such activities are not incompatible with the other uses of the building. Now, if you adopt that as a principle, why do you need a public forum doctrine? You don't need it. Doesn't it totally gobble up the concept that there are some public buildings where you don't even have to have reasonable time, place, and manner restrictions?
Your Honor, one important element of our analysis on this compatibility issue is that there's general access open to the public. And if let's take an office building as a good example. You have an office building, narrow quarters. There is an argument can be made that the activities taking place inside an office building may not be compatible with the efficient operation of that particular facility. But it's that general public access coupled with the compatibility.
But even in a public forum, you are allowed to place such restrictions as are necessary to make the speech compatible with whatever else is going on there.
That's correct.
In a park, okay, and so forth. So then what difference is there between a public forum and a non-public forum in your view of the world?
A non-public forum, and arguments have been made regarding a non-public forum concerning the internal mail school systems. It's that public access was lacking, Your Honor, in that particular situation and many others. There are also cases like Greer v. Spock. There are special functions of facilities, military bases, where that special constitutional function is what this Court determined. That special constitutional function justifies the concern for national security, justifies in national defense the regulation or elimination in some cases of First Amendment activities from taking place. We're not saying that all facilities are public forums open to everyone. What we are saying is when you have that compatibility and general public access, that is what we're saying is part of the key, that compatibility and access. That's a balancing. The public forum issue is on a spectrum. Our position is that LAX on the spectrum of public forum is closer to a street, a sidewalk, or a park than it is to a military base or a prison.
We're taking the position that they're all public forums if there is general public access. The only inquiry you would make, once you've determined that there is general public access to the building, is whether free speech activities are compatible.
If there's general public access and compatibility, our position would be that a public forum should exist, subject to special concerns such as a military base or a prison if there was an area that was general access. The Court's decisions regarding in Greer v. Spock, although the military base was open, there are special constitutional functions there.
And the question of whether it's appropriate isn't necessarily the same as the question whether it's compatible. Take my hypothetical about the Capitol. It's compatible in the sense that they can run their business over there with booths passing out religious literature and political literature. They could run their business anyway, but it's just never been done. This is not the place for it. They have just said it's not the place for it. You would not allow that to be said, would you?
Your Honor, the position of something not being the place for the activity is something that we think is exactly why airports would be a traditional public forum. I don't take the position that the grace of government is the determining factor of what constitutes a public forum. Nor do I take the position that a mere chance of history, if you will, would create the public forum, or increased mobility of society, or, for that matter, new architectural designs. An excellent point was raised with what if the airport extended its central terminal area out to the sidewalks and covered it? Well, is that now banned? And that's the position we're taking. The compatibility is an important factor. The public access is an important factor. The accommodation of it, we would take the position that it's an analysis that has to draw a balancing. There has to be a balancing there. The balancing would take into consideration these other positions.
In 1987, the United States Supreme Court issued a unanimous opinion that opened the door for evangelism and distribution of literature in the nation's airports.
Because of that decision in Jews for Jesus, we opened up areas of evangelism literally from coast to coast. I mean, we marched around the country defending evangelism in Chicago, in Boston, in New York, Atlanta, Texas, Southern California, Northern California, and points in between. And we won all of those cases because of a unanimous decision in Jews for Jesus.